Well, good evening, ladies and gentlemen, and welcome to this second International Judicial Summers lecture. It's the first season in which we've been running these, and this is a very welcome second lecture on international human rights. I'm delighted to welcome all those who have joined us in person this evening, and we also have an online audience who are able to follow this remotely. Could I please deal with some points of housekeeping? Firstly, this event is being recorded and will appear on the Inner Temple website, so please don't shout out anything inappropriate, and a link will be sent to guests afterwards. Please can you ensure that mobiles are turned off, including those in the front row who have just had a BBC News alert, and please can students who require this to be a qualifying session credit sign the sheet in the reception area before leaving, or you may not get your credit. This session is not a qualifying session for non-Inner Temple students, I'm afraid. Practicing barristers can obviously keep a note of this event for their CPD records. There will be an opportunity for those in person as well as those attending online to ask questions of our panel after the various presentations. Members of the audience in the lecture theatre should please use the roving microphone as and when it's provided during the Q&A. Members of the audience online, please use the Zoom webinar to submit questions at any time during the presentation, and then I will magically be given an iPad that picks the questions as and when they come in, and we can hopefully get through as many of those as we can. Questions can either be addressed to an individual panellist or the panel as a whole, but do try and keep the questions short and sharp because we will be able to cover more ground that way. I'm delighted tonight to introduce three very distinguished speakers. The American jurist Oliver Wendell Holmes famously said that the life of the law has not been logic, it has been experience. And this panel is a testimony to that epithet. Master Anne Power is an Irish judge who currently serves as a judge of the Irish Court of Appeal and has done since November 2019. Before that, she presided over the Kosovo Specialist Chambers and Specialist Prosecutor's Office from 2017 to 2019 in The Hague. That's an international court established with a specific jurisdiction to try serious international crimes, including war crimes and crimes against humanity. She served as a judge of the European Court of Human Rights in Strasbourg from 2008 to 2015, and as a member of that court, she worked on several pressing concerns, such as the legacy of the invasion of Iraq, the annexation of Crimea, consequences of global terrorism, the refugee crisis in the Mediterranean, and the legacy of European genocide. Judge Power has just been appointed to chair a tribunal of inquiry into the Irish Defence Forces and allegations of abuse by those forces, a role that's likely to keep her busy for the next 3 years. To my left, Naina Patel is a colleague of mine, barrister at Blackstone Chambers. She specialises in administrative and public law, as well as regulatory law, EU and competition law, commercial law, civil liberties, human rights, immigration, public international law, and the rule of law. And in her spare time, she doesn't have any, she has an active spare time with her family and other things. I'm leading Naina in a case at the moment, and she's an absolute delight to have as a senior junior. She represents a diverse clientele, including international organisations, states, companies, and individuals. She's a member of the Attorney General's Civil and Public International Law panels, the EHRC's panel, and the UNHCR's Pro Bono panel. She's also an expert member of HMG's Civilian Stabilisation Group, providing justice and security advice to the MOD, FCDO, and others. To my right, to the other side of Judge Power, is Master Andrew Cayley. He's currently a principal trial lawyer at the International Criminal Court. From 2021 until February 2024, he served as His Majesty's Chief Inspector of the Crown Prosecution Service. Prior to that role, he was Director of Service Prosecutions from 2013 to 2020. Between 2009 and 2013, he served as the International Co-Prosecutor of the Khmer Rouge Tribunal in Cambodia. He worked as trial attorney and senior trial attorney at the ICT for the former Yugoslavia and the International Criminal Court in The Hague from 1995 to 2007. He was involved in the ICTY's first conviction for genocide related to events in Srebrenica in July 1995. What an amazing series of experience that we have before us this evening. It's my great delight to introduce the Honourable Mrs. Justice Anne Power to give the keynote address for this session.
Good afternoon, good evening everybody, and thank you, Master Beal, and indeed all those at the Honourable Society of the Inner Temple for the invitation to speak here this evening. It really is a great pleasure. I indicated that I wouldn't give a formal academic paper, so this is not ready for publication in the Oxford Law Review or any other review, but I would speak from my experience of having served as an international judge, particularly on the European Court of Human Rights. I'll give you a little bit about my background, and then I'll move into what I think is the fundamental principle driving all international human rights law, which is the concept of human dignity. I'll talk about a couple of cases that I was involved in where respecting human dignity might present itself as a challenge, and then I'll wrap up with some concluding remarks. So, my background, I was and trained as a secondary school teacher of English, and I loved every moment of it. I couldn't believe that they paid me to do my job. And then, quite by accident, I stumbled into the law, and I loved that too. And in 2007, late 2007, I was asked by the representative of the Irish government if I would allow myself to be nominated to serve as a judge of the European Court of Human Rights. I didn't see it coming, you know, I was totally blindsided by it. And I thought, oh, what a tremendous privilege to be in a position where the community, the international community, trusts you to make a decision which is in accordance with the requirements of the European Convention on Human Rights. So when I got to Europe and when I got to Strasbourg, I saw my country from a different perspective. It obviously, when one misses home, it takes on a particular glow, but I was very proud of the reputation of Ireland amongst the international community. It was a challenge because I regarded myself as having been the happiest barrister in Ireland. I absolutely loved what I did. And I remember in the first couple of months when I got to the court, I was somewhat surprised because the weekly docket, maybe 80% of the cases on the weekly docket were repetitive cases where perhaps 500 euros or 1,000 euros were being awarded to some rich lady in Geneva whose grandfather's property in Bucharest had been expropriated during the war, but hadn't been returned on time, so there was compensation for non-execution of judgment, a delay in executing the judgment. And I thought, what have I done? I've given up my practice before the Superior Courts of Ireland, and I loved it. It was constitutional law, administrative law, and medical law. And suddenly I found myself in what I thought was something of a small claims court where these cases just kept coming and coming and coming. But over time, that focus on the repetitive cases changed, and the court adopted procedures whereby the more serious human rights violations were kind of moved up the list rather than dealing with cases on a first come, first served basis. But what I learned when I got to Europe was that the sensitivities of the Second World War were palpable. I learned about the Second World War as a secondary school student, and I thought it happened eons ago. You know, the World War was a long, long time ago. When I got to Strasbourg, I realised it happened only yesterday, and that the gross violations that were exposed during the Second World War, in many ways, when it came to individuals, they were happening again on our watch. We were seeing people humiliated, we were seeing their rights disregarded, we were seeing people drowning in the Mediterranean, people being returned to places from which they have fled. And, you know, I was left with this really strong sense that we cannot take for granted the fact that we now have respect for international human rights. It's a day-by-day process. It's a daily process of respecting what is at the core of the human being, and we cannot simply take it for granted. And as you know, the convention itself was set up in reaction to the war, as a response to the Second World War. Its rallying cry was never again will the European societies that signed up to the convention permit their subjects, their citizens, to be treated in a manner that violated their fundamental human dignity. And never again would those countries who were signatories allow their citizens to evade international scrutiny. So there's been a lot of talk, particularly in recent times, and I'll come to it in a moment, about loss of sovereignty, and, you know, being part of Europe means you're somehow less an individual. But I never saw adherence to the convention as in any way a loss of sovereignty. It was a pride in sovereignty. We're proud of the way we treat our people, and we're quite happy for the international community to assess the extent to which we comply with our international obligations under the Convention. And I think it's timely for us to reflect upon what's happening in Europe at the moment. The European project, I fear, may one day be seen as an experiment. The post-war European project, where Europe came together, promised that it would never allow those atrocities to recur. We may look back one day and say, that was a nice experiment. It lasted 75, 80, 100 years, but it's over. And I grew up in a world where I took for granted the fact that I could travel throughout Europe, I could live in any other country in Europe, I could study, anywhere I wanted to. It was a given freedom as far as I was concerned. But it wasn't a freedom that my grandparents had or their parents had. And it's not a freedom that was easily earned. It's not a freedom that was lightly won. And I suppose that really, when I approach the Convention and the whole question of human rights violations, I see that at its core is respect for human dignity. And human dignity is a concept that's common to, many ancient religious beliefs. It's also a common thread in political and legal documents like the Universal Declaration of Human Rights. And it's also the founding principle of the European Convention on Human Rights. And I suppose at its core, what it says is that to be human, dignity at its core, to be human is to be of value. To be human is to be of value. And just as membership of a natural family carries a shared genetic imprint, so membership of our human family carries that shared imprint of value, as it were. That I can never look at another human being and think, you're not one of us. You mightn't look like me, you mightn't talk like me, but you're part of the human family. And like every human family, you're going to have all sorts. And I'll come to those various members of the family in due course. But I suppose the Convention was also then inspired by a commitment to memory, a commitment not to forget what human beings are capable of when we forget that every one of us carries that shared imprint of value. I love the line from Solzhenitsyn when he said, the line dividing good and evil doesn't run through the hearts of states and nations. The line dividing good and evil runs through the heart of every person. And that's something I think that we have to remind ourselves of time and again. And I suppose the Convention also recognizes that human rights come with the territory of being human. It's because you're human, you have human rights. Human rights are not something that the state grants to you if you're good, as it were. Human rights come with the territory of being human, and the state may only interfere with those rights, in limited circumstances. And it must justify the interference, and it must have a legal basis. Any interference must have a legal basis, and it must be necessary, and it must be proportionate. So rights aren't something the state gives us, they're something we have, they adhere in us because we are human, and as I say, where there's any interference with those rights, they have to be justified and they have to be proportionate. And of course, the Convention recognizes something which is probably not that common today, and that is that there exists this concept of absolute human rights. Some rights are absolute. Article 3, for example, which prohibits torture and inhuman and degrading treatment, it's a fundamental right and it's absolute. There is no derogation from it. There is no justification for any departure from it. It is absolute, and states who sign up to the Convention recognize the absolute nature of that right. And that's something that we're struggling with today, because there's perhaps, in the post-Enlightenment period, the rise of relativism, which says, well, what's good for you is good for you, and what's good for me is good for me, and we can all choose, what is of value to ourselves. But I think it is important to recall that the Convention itself, as with the Declaration, the Universal Declaration, does recognize this concept of absolute value. Now, I think times are changing in Europe, as I mentioned earlier, and we see this fracture, at least, in some European states. We see, what might be described as the rise of particular interest groups, the far right or the far left. We see divisions among society. We see things which frighten me sometimes because they're kind of reminiscent enhancement of the language that seemed to predate many major international crises. Scapegoating, for example, pointing to one group and saying it's their fault we're in the situation we're in. Whether that's a religious group, whether that's a group of immigrants, this concept that I can blame the other for the problems of society. I find I'm hearing that. We've just come from Dublin where there were protests, and they weren't protests actually. Our Taoiseach said, no, they're not protests. When you throw bombs and petrol bombs, that's not a protest. And again, it was built on this rhetoric of the other and the danger of the other. And I think these threats to our democracy, they're real and they require that we remain vigilant. But I suppose one question that might be asked is, how can we respect human dignity in really difficult times? How do I respect the dignity of somebody who has no respect for mine? Whether that's somebody who enters the country without any lawful basis, or somebody who commits the most awful crimes against another human being. How it calls upon our deepest resources, I think, to still insist that that individual person, particularly those who commit heinous crimes, that individual person maintains his or her character as a human being and is of value, even if the behaviour of that person is not, and even if the behaviour of that person is to be condemned. And I thought that what I might do is take a look at some of those cases where, in the Strasbourg case certainly, there was at least a challenge or an argument raised in relation to the rights of such individuals. And one of them was a case against the United Kingdom. It was Winter and others versus the United Kingdom. And many might recall that was a case where the applicants had committed very serious offences and had been sentenced to life imprisonment without parole. Whole life sentences, I think, is how they were described in the United Kingdom at the time. And they came to Strasbourg and they claimed, these individuals claimed, that to impose upon them a whole life sentence without the possibility of parole violated their human dignity, their rights under Article 3. And I always think of this line in Dirty Harry. You're probably all too young to remember Clint Eastwood in Dirty Harry, where he's going after the bad guy, and the bad guy is insisting, I have human rights, and Dirty Harry, I'm all cut up about your human rights, because there is that sense, well, you didn't respect the rights of others. And although that's a movie, I think it does challenge us to confront the difficulty in respecting and vindicating the rights of those who don't respect the rights of others. And I remember in that case, the Grand Chamber deliberated and decided that yes, to deprive these individuals of the possibility of parole, notwithstanding the terrible offences that they had been committed, that did indeed violate Article 3 of the Convention. And I remember going back to my room, and I said I'd speak from a very personal perspective, but I remember going back to my room and struggling with it, because I was thinking of the families of those victims, and I was thinking of the life sentences imposed upon them when their loved ones were no longer around, or the suffering that had been imposed upon the victims themselves. And I was trying to weigh up, what does the Convention require in these circumstances? But then another movie, I thought of Shawshank Redemption, and I thought of Red, and I thought of, the fact that he's 65 or 70 and he's going in looking for parole every year, and every year it's rejected, and he puts his little speech about how he's been rehabilitated, and of course he's a good guy, and then eventually he gets tired playing this game, and he goes in and he tells the truth, and he says, I don't really care what you and your smart suit think, you young mister. All I see is a young kid who made a stupid mistake, and I want to talk to him, and I want to tell him how it is. I want to tell him what life is about, but I can't, because he's gone, and this is all that's left. And that reminded me that human beings retain within themselves always the capacity to change. They may not change, but they retain the capacity to change. And for me, this was fundamental in my explanation as to why I could agree that to impose a whole life sentence on a person did in fact violate Article 3 of the Convention, this prohibition on inhuman and degrading treatment. And I remember writing the shortest separate opinion I've ever written in my life. It was a 2-paragraph opinion, but I was attempting to explain, perhaps to the victims' families of these individuals, or the families of the victims of these individuals, why it was that I believed that would violate Article 3. And I said, those who conduct the most abhorrent and egregious of acts and who inflict untold suffering upon others, nevertheless retain their fundamental humanity and carry within themselves the capacity to change. Long and deserved though their sentences may be, they retain the right to hope that someday they may have atoned for the wrongs which they have committed. They ought not to be deprived entirely of that hope. To deny them the experience of hope would be to deny a fundamental aspect of their humanity, and to do that would be degrading. And that was the way I could explain to myself and accept the vote that I had to take in that particular case. For me, hope is constitutive of humanity. It's like freedom. It's something that's intrinsic to what it is to be a human being. And by hope, I don't mean naive optimism. I hope I win the lottery. That's not what hope is. It's something much more fundamental, and it's somehow a belief in the capacity that things can be other than they are. And that applies to human beings as well. Now, another vulnerable group, apart from prisoners, who might present a challenge, may be immigrants who come to a country, perhaps not genuine, in inverted commas, asylum seekers, but those who are looking for a better life, as most people do. And there was one such case before the court, and it involved a young lady, it was SJ in Belgium, and it involved a young lady who had come to Europe a long time ago. I think she had gone to live with the father of her children at the age of 11, and she had 3 young children by the time she reached Belgium, and she was HIV positive. And the doctors in Belgium had taken a lot of care to try to find out the precise antiretroviral medication that worked for her. And eventually her CD count was stabilized, and she had an almost normal life expectancy. And the decision was, in the light of M versus the United Kingdom, a case against the UK, also involving somebody who was HIV positive, the decision of the Chamber was, it's not a violation of Article 3 to return her to her home country. And I remember I struggled with them anyway, and of course judges have to apply precedent and follow precedent. But if we can distinguish a case, if we can say it's not quite the same as that, it gives a chance for the Grand Chamber perhaps to look at whether the convention needs to be interpreted slightly differently. And I remember going back to during that particular case, the argument was, of course, well, we're applying N, this is the same, and I think one of the phrases used in one of the dissenting opinions in N was that Europe cannot become the sick bay of the world, and we can't have everybody coming to Europe, because they don't have access to medical treatment here. But unlike N versus the United Kingdom, there was something about this case that struck me. In N, if you read the Grand Judgment's cases in N, there was a certain amount of comfort taken from the fact that perhaps when N was deported back to her country of origin, perhaps she would have access to antiretroviral therapy or treatment. That this was a growing possibility. Whereas unlike N, we knew for certain that in SJ, there was no antiretroviral medication of the type she needed in order to give her a chance of living. And I also distinguished it, and I thought, she's the mother of 3 children. Not only will she die from AIDS and die a most horrible death, and I've seen children die from AIDS, and it's a really awful death. Not only will she die, but she will die having to watch her 3 young children watch her die. And what kind of hopelessness does that bring? And I remember thinking, as part of the case law of the court had said, Article 3 can only be invoked in these cases. And the principle was articulated in another case of D versus United Kingdom, where the person is on death's door, where if you were to send them back, they would die on the street, as it were. But I thought to myself, but Article 3 is about the right Article 2 is about the right to life, and Article 3 is about the right not to be treated in a degrading and an inhuman manner. And, if the right to life meant anything, surely it meant the right to be given a chance at life. This was the view I took anyway. So again, I wrote the strongest dissenting opinion I think I've ever written, trying to distinguish the case from N versus the United Kingdom, and trying to show the contrast between the court's approach to this particular individual and to, for example, international suspects who were required to be returned to the US to these supermax facilities. And the court had already found that to return a person from the UK to a supermax facility in the US would violate Article 3 because he had mental health problems and he would be returned to a hostile environment which wouldn't be conducive to his well-being. And for me, well, we were taking this woman from Belgium and returning her to an equally hostile environment that wouldn't be conducive to her well-being. So I wrote this dissent, and I suppose I was hoping the Grand Chamber would pick it up, and I was ringing alarm bells, as it were. And the Grand Chamber did pick it up. The case was referred to the Grand Chamber, and ultimately the countries settled the case. Belgium entered into an agreement or a settlement with the case. But the woman, I hope, is alive and well in Belgium. And it reminded me, I suppose, that case of the importance for all of us, particularly young people, I think, to know that every decision we make in life can have an impact. Every decision can have an impact way beyond anything that we can imagine or contemplate. I remember, for example, when I was about 14, coming home from school and announcing that I had left school. I was finished with this whole education project. It wasn't for me. I didn't get on with the head none. You know, it just wasn't for me. And as far as I was concerned, I had left school. And September rolled on and my father said to me, you know, get your uniform ready. We went to Catholic girls' schools and we all wore uniforms. And I announced, but I've left school, Dad. And he looked at me and you haven't left school. And I had, and this row went on for 3 days and 3 nights. And I said the most awful thing to my father. I said, I will hate you for the rest of my life if you make me go back to school. And he looked at me and he said, I don't care if you hate me for the rest of your life. You're going back to school. And back to school I was marched. And what I often think about was that the decision he made then, that night, he was a bus driver, he was tired, you know, he'd come in from a long day and here's his truculent teenager being stroppy and arguing and fighting. But I often think the decision he made that night, through a chain of cause and effect, somehow had an impact upon that same truculent teenager 30 years later, when she sat on the world's largest international court and penned this dissenting opinion with her own heart pounding because she thought, oh, here she goes again. But somehow the decision that he made that night had an impact upon that decision I made 30 years later. And because of his decision, a young woman gets to be alive with her 3 children in Belgium. So I always say, let's not forget the impact which our decisions can have upon others. And we mightn't see that impact, but it's there. So I'm very conscious that I've gone over time, and I'm just going to make a couple of concluding remarks. And that is that, as I said, human rights recognizes that the basic fabric of the human being, our basic DNA, as it were, is the same. And that, like any family, you have the good, the bad, and the ugly. We all have those members of our families that we probably prefer we didn't have. And the human family is no different. But if we ever take the path of thinking that some humans are less valuable than others, are of less intrinsic value than others, then we open up the pathway to the most horrendous possibilities. And we just don't know, I suppose, really, what the big picture is all about. But respect for human dignity and for recognizing that the person that I may despise, the conduct of the person, the conduct I may despise, but the person itself, himself or herself, is a person of value and therefore, you know, is entitled to the respect and the application of all human rights instruments insofar as they apply to him or to her. And I'd like to end with a little quotation, because I think, certainly for me, the work that I do, I have to see it in the context of a mosaic, as it were. I don't know the ultimate impact which anything I do might have, but I see it as a little tile in a mosaic, a picture that's certainly bigger than myself. And a lovely old philosopher friend of mine from Ireland, he's dead now, but he wrote, what we are between birth and death is not the whole story. What we are in the universe is not the whole story. The universe itself is not the whole story. And as we pursue our search for meaning and work for the recognition of the right of every human being, may we never forget that respect for human dignity is an intrinsic part of the whole story. Thank you very much.
So, notwithstanding having been handed the magic iPad with all the online questions on, we're not going to take questions or have any answers at this stage. We're going to move on to Naina Patel and have the presentations, and then with your blessing, we'll have questions at the end. Thank you.
What a humbling act to follow. I'm going to make the task a little easier for myself by, as the most junior member of this esteemed panel, hoping to achieve three things with my short presentation. Firstly, to give you a view of my route into the human rights work that I practice. Secondly, to try to illustrate with some examples of cases that I've been involved in how human rights can arise in many different guises and fora. One of the cases I will talk about is a Strasbourg case, but the others are not, but they do involve human rights. And then lastly, to finish up with some ideas for those of you who are here for qualifying sessions about opportunities for getting involved in this sort of work in your future career. So to give you an overview of my practice, to distill down the long list that Kieron gave you, principally my practice is in public law, public international law, often in the domestic courts, and human rights in regional and international courts. And I'll draw on examples from each of those areas. Why did I want to do this work? I've always been interested in improving the world, and I had a particular interest in how law could help societies function better. I read a book by someone called Hernando de Soto when I was about 18 called The Mystery of Capital, which was about a very simple idea that fueled development in the part of South America that he was from. It was the idea that if you could crystallize a property right in a deed to show that you owned land, you could then take it to the bank and get collateral on it. And this very simple concept was used to basically drive ways for farmers to develop opportunities for borrowing capital to then improve their yield and improve the livelihoods of their families. And I found it such a striking idea that it sort of took me on this route into looking at how law could be used to help build societies generally, helping them recover from conflict, helping them grow economically. And so that led naturally into ideas of international law and human rights more generally, the role of international law in international affairs, the UN Charter, international humanitarian law, the role of law in accountable government, constitutional law and judicial review and the role that that plays, and the role of law in promoting growth, contract law, land law, and accessible means of dispute resolution. Human rights is a key part of all of that, from the role it plays protecting civilians in international human rights law, to the role of individuals in holding governments and corporations to account, to how the individuals can be used to keep dispute resolution processes fair. So that took me on a journey to a non-law degree in PPE, Politics, Philosophy and Economics, a law conversion course, and then a master's in public policy at Harvard, which involved international law and human rights, as well as international development. While I did the BBC, I worked for an NGO called International Rescue Committee, which took me to various places recovering from conflict, including back to Afghanistan. My internship at Harvard took me to Afghanistan, I think 2 years after the Taliban were ousted. And then pupillage and my early years of practice, in a way, I think built on some of that non-legal work I'd done. In my early years, I was involved in a lot of the cases arising from the UK's role in Iraq and Afghanistan, including Al-Sqaini when it went to the Grand Chamber. I worked on the Guantanamo litigation involving British and dual nationals who were rendered to Guantanamo. And I was involved in project work through organisations like the Bar Human Rights Committee, which took me back to Afghanistan for 3 years. We developed a project to stock 5 university law libraries with second-hand law books. So those old volumes of the White Book that we often used to prop up our computers to make the screens the same level found, I think, a more useful home in Herat and other provinces in Afghanistan. And I joined several pro bono panels like the panel of the UN High Commissioner for Refugees. Around 2010, I took a sabbatical to be a senior justice advisor to the UK's provincial reconstruction team in Afghanistan. And my job for a year and a half was to try and build a functioning state-based legal system in Helmand province. And then I came back to the UK and back to practice, and I took on a part-time role at the Bingham Centre for the Rule of Law, again, helping with judicial training and constitutional projects in places like Libya and Burma, helping DFID develop its new rule of law strategy for helping countries overseas, and helping the Open Society Foundation with how we might take basic legal services to scale around the world through something like a global legal fund, in the way that we have a global AIDS fund and a global education fund. Since about 2015, there's been some retranchement. I have 3 children now who are 6, 4 and 2, and so my focus is on practice only. And that brings me to the examples of cases that I wanted to mention. I've chosen 4 examples going up from first instance to the European Court of Human Rights in an effort to give an overview of the different ways that human rights can come into domestic practice as well as practice before international courts. My first example is a judicial review public law case from this jurisdiction. I've mentioned Afghanistan a few times. You will all be depressingly familiar with what happened in Afghanistan a couple of years ago. And you may be familiar with the fact that a resettlement scheme has been put in place by our government for those that are deemed to have worked in support of what the UK was doing there for many years. And that resettlement scheme puts people who can be established to be at risk as a result of their work with the UK, gives them eligibility to come here and settle here. There are lots of cases that scheme throws up, challenges to failure to make decisions at all. There are individuals who've been waiting years now for decisions. There are challenges to decisions who are not eligible for resettlement, and that is deemed an incorrect decision. And there are challenges to decisions even in relation to those who've been found eligible for resettlement. An example of that third category is a group of cases that came before the Administrative Court last autumn, which related to people who had been found eligible for resettlement and had been accommodated in Pakistan pending coming here, but had in fact been there for months, coming up to a year, with their families, young children, unable to leave their hotels, no schooling available for their children, and in a situation where their Pakistani visas had expired. You may have seen in the news that towards the end of last year, Pakistan announced that anyone who was there on a expired visa would be expelled and deported back to Afghanistan as of the 1st of November. So this led to proceedings involving a group of Afghans in this situation. And in the course of those proceedings, it became apparent that the delays in bringing people here were due to a secret government policy which had decided that instead of bringing people here to put them in bridging hotels while long-term accommodation could be sorted out, it was decided that they would remain in Afghanistan until a long-term accommodation option could be sorted out. And the difficulties and the local authority shortages involved in that meant that, in fact, people were being offshored for very, very long periods of time indeed. Now, that is, I think, an example of what Master Power has described as human rights in difficult times. We're all well aware of the public funding shortages here, the housing shortage, and no doubt there are large constituencies that will have been supportive of that decision not to use public money on bridging hotels. But the result of that was that people that we had promised we would bring here, because of the work that they had done with us on the front line, were being put in this situation. And I'm happy to say that during the proceedings, the policy was withdrawn and resulted in a plan for bringing all those affected to the UK in short order. And all those who were my clients that brought claims are now here. My second example is a commercial case, in fact, and I mention it because of what I explained about the desire to show how human rights can crop up in all guises. It's again a first instance case, but it's going on appeal to the Court of Appeal later this year. It concerned an appeal against the registration of a foreign judgment for sums that were due under an insurance agreement following the loss of an oil tanker called the Prestige, which sank off the coast of Galicia, Spain, in November 2002 and resulted in a catastrophic oil spill. The foreign proceedings had involved a Spanish appeal court convicting the ship's captain of disobedience and acquitting him of the offence he'd been charged with in the lower court, and then holding the captain and the owners and the insurers civilly liable for the damage. The appeal alleged that the underlying Spanish judgment had been obtained in breach of fair trial rights, Article 6 and Article 14 of Article 6 of the ECHR and Article 14 of the ICCPR, the International Convention on Civil and Political Rights. And the argument ran that to recognise that judgment in the UK would entail a manifest breach of English public policy because of those underlying human rights breaches that were alleged. The case raised fascinating issues, such as, can it be a breach of English policy to recognise a judgment where the complaints of breaches of human rights have in fact been dismissed by the relevant international court? And these ECHR breaches that were complained of had in fact been taken to Strasbourg. They had been dismissed at the admissibility stage by a single judge, and there were in fact complaints that that process had been unfair because the judge who had determined the admissibility complaint had been a judge of Andorra, which is a principality of France and Spain. So the allegation was that that wasn't the fairest of decisions that it might have been, put it no higher than that. So fascinating issues about the interplay between the decision of a regional court and what a domestic court should do with that, as well as issues about where one of the breaches relates to an article that is not part of the ECHR and is only in the ICCPR, in this case to do with the right to a higher review of a lower decision. The ICCPR is not incorporated in England and Wales the way that the European Convention is. So can an unincorporated treaty obligation like that be said to be part of English public policy? And as I say, we were successful at first instance, but it's going further and we'll see what the Court of Appeal says. The third case is a Supreme Court case. And the last thing I wanted to say about that case is that from what I've said, you'll see I was on the side of Spain, not the side of the individual. But what that case threw up was that Spain's argument was about the catastrophic oil spill and the huge environmental damage that ensued. And one thing that I think is very interesting about how law is developing, especially in Strasbourg at the moment, is this interplay between environmental rights and the rights of the individual. And I think it's an area where we may well see both synergy and conflict as the jurisprudence develops. So back to the Supreme Court case. That was the case of Maduro board of the Central Bank of Venezuela against the Guaido board of the Central Bank of Venezuela. And it concerned a battle for control over some 2 billion of Venezuelan gold reserves, which were held at the Bank of England. Mr. Maduro had been re-elected president of Venezuela in May 2018, and Mr. Guaido was president of the National Assembly of Venezuela. And both parties had appointed boards to the Central Bank of Venezuela that had issued conflicting instructions about what should happen to these gold reserves. The case raised issues of head of state recognition. Who did the court recognise as the head of Venezuela? And which board therefore properly represented the bank? The Foreign Office, the UK Foreign Office, had issued a statement saying that Guaido was the constitutional interim president of Venezuela because they considered that the election of Mr. Maduro had been deeply flawed. And the court had to essentially decide whether that was correct, that they were going to recognise Guaido as the president of Venezuela and the head of state, or not. And the background to the case was allegations about what was said to be the very serious human rights record of Mr. Maduro. So again, an example of how human rights can, in fact, be a very large part of what the dispute is about without being perhaps sent in front of the legal analysis. It wasn't a case about the ECHR or any other international human rights article. But the backdrop was very much about human rights and what the UK government's position was in relation to recognition of those involved. And the result of that case was that the one voice doctrine, which means that the organs of a state, so the courts, the executive, and Parliament must speak with one voice, meant that the courts were bound effectively to accept Her Majesty government's statement about who the President of Venezuela was. So I think that is an example of the limits, the jurisdictional limits that can be placed on what the available arguments are in a particular case. And my last case is Ukraine against Russia, the Strasbourg case that I mentioned. This is an interstate case which is ongoing at the Grand Chamber, which concerns Ukraine's allegations of all the human rights violations that have been committed by the Russian Federation in its military operations on the territory of Ukraine since the 24th of February 2022. It's the largest case ever to reach the court, as I understand it, and it seeks declaratory relief as well as compensation for all Article 1 of the First Protocol claims for damage to private property that has occurred since the invasion. So the sums involved are also vast. Russia withdrew from the Council of Europe while we were preparing the case, which raised interesting questions about the court's jurisdiction temporally. The case also raises issues about geographic and substantive jurisdiction because, of course, we're talking about violations of the convention that have happened in the course of active hostilities throughout this period from February 2022. I was part of a team of 10 juniors and 2 silks in a case which ultimately involved, I think, 26 intervening states, including the UK, who had particular concerns about how the concept of jurisdiction was going to be interpreted, given its position in historic cases concerning Afghanistan and Iraq, indeed Al-Skaini. The hearing took place on the 12th of June, so we are awaiting the court's decision. But it was a fascinating case to be involved in because we were gathering a factual chronology in real time, drafting our submissions to the court as things were happening on the ground. I remember we were identifying administrative practices, which are repetitive patterns of acts which are subject to official tolerance, which is one of the answers to whether you have exhausted domestic remedies. And we were identifying that one of Russia's means of warfare, it appeared to be this siege of places like Mariupol. And we were drafting these submissions while we were watching the news in real time to see what the latest situation was in Mariupol. Similarly with the kidnapping of mayors, again, one of the modus operandi seemed to be to take high-ranking civilian officials, kidnap them, sometimes release them, and sometimes not. So really challenging situation in which to be drafting. I've mentioned the fact that Russia withdrew from the Council of Europe in real time. So we were, as we were drafting, having to establish what the consequences of this were. Would the court only have jurisdiction until September? Would it in fact have jurisdiction over everything that followed because Russia was a member at the time this continuing set of hostilities began? Real challenges obtaining sources of evidence, testimony or other, and a real need to think about justice in this individual case versus the principles established for the future. Master Power talked about the World War II settlement and how recent it was. And I think that case is a really good example of how recent that settlement was. It was a very moving hearing where I think what was foremost in everyone's mind in the hearing room was the desire to make sure that nothing like this happen again. People often say, well, what is the point of human rights litigation? The judgments that international courts produce are not enforceable in the normal way that we would understand domestic judgments to be enforced. What was the point in a case like that? I think firstly, the role of an award in standard setting for wars of aggression in the Council of Europe space. Ukraine and indeed the rest of the Council of Europe states obviously feel that it is very important to lay down a marker that this course of action is not acceptable and should never happen again. There's also the role of such an award in any peace settlement. So it may be that the court issues a judgment and Russia, I think it's fully expected, will not comply with any award. But that doesn't mean there's no role for such an award in any peace settlement discussions that there might be in the future. And then there is also the potential role of an award of the court in relation to frozen Russian assets. There are extensive Russian assets frozen in this jurisdiction. And if legislation were to make it legitimate to seize those assets in execution of a judgment of a foreign court like Strasbourg, then again, that would make an award of that kind valuable. I'm over my time, so I'll finish with three suggestions for opportunities for getting involved in this sort of work in the future. My first point is do what interests you. You'll have seen from what I've described that I was very interested in international development and how law could be used in that sphere. It turned out to be valuable and relevant experience, valuable because you have an idea of work on the ground and the challenge of working in jurisdictions like that. And I think it probably played a role in being involved in some of those early cases concerning Afghanistan and other conflict zones. Secondly, in your early days, seek out pro bono opportunities. There are university organisations that are involved in amicus briefs. There are bar organisations that are involved in amicus briefs like the Bar Human Rights Committee. And thirdly, take a broad view of a human rights practice. Human rights and the concept of human dignity can arise in lots of cases, in lots of fora, in different ways. If you take a broad view, hopefully you'll scoop up lots of experience in different ways, in different cases where human rights throws itself up, and you'll find the place that best suits you and your future practice. Thanks very much.
Thank you very much. Last but certainly not least, we now have Master Andrew Cayley talking about his experience in the international criminal sphere.
Thank you very much, Master Treasurer. Ladies and gentlemen, good evening. I think I'm going to try and rattle through this in about 2 minutes.
Do take longer because we'll just we've got until 7:30 or so.
Okay, so I'll try and move this. I'll try and move as quickly as I can. I'll make an immediate admission to you. I'm not a human rights lawyer. I've spent the largest part of my career concerned with international criminal law, which ultimately involves the prosecution of individuals as opposed to states being made responsible with gross violations of the laws of war, also more commonly known as war crimes. Now, the law of war, the laws of war, also known as the law of armed conflict, also known as international humanitarian law, is a set of rules that seeks for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or are no longer directly or actively participating in hostilities. So here we are speaking of civilians and prisoners of war, and it also imposes limits on the means and methods of warfare. International humanitarian law is in fact part of public international law, which is made up, many of you will know already, primarily of treaties, customary international law, and general principles of law. Now, looking specifically at the relationship between public international law and international humanitarian law, one needs to go back a very long time, first of all, to look at international humanitarian law. Where did it come from? Well, as I've said already, the laws of war have always existed to limit the worst excesses of warfare. The ancient civilizations, the knights of the Middle Ages, the jurists of the early modern period, all testify to the record of this concern. And it's not just a Western concern. Other cultures such as China, Japan, India, and the Islamic world all have their own traditions around the rules of warfare. Yet, despite this ongoing universal concern, the attempt to limit the manner in which wars were fought had suffered many setbacks. It was not until the 19th century that a movement could codify the laws of war when modern international humanitarian law was born. So codification dates back to 1864, when the Geneva Convention of August 22nd of that year for the amelioration of the conditions of wounded in armies in the field was drafted. This convention was followed by a range of treaties, each of them the product of the acknowledgement that individuals needed to be protected in times of armed conflict. Now, modern human rights law as has already been touched upon, largely developed after 1945. Prior to this, there had been a number of written instruments, generally limited to a single state or nation, asserting certain rights of individual human beings. So, for example, the Magna Carta of 1215, the Petition of Right of 1628, the United States Constitution of 1787, the French Declaration of the Rights of Man and of the Citizen of 1789, and the US Bill of Rights of 1791. But human rights only entered the world of public international law as a result of humanity's shock at the victims of a new kind of internal war, the victims of the Nazi death camps. The Universal Declaration of Human Rights, which was adopted by the General Assembly of the United Nations on the 10th of December 1948, was the direct result of the experiences of the Second World War. With the end of that war and the creation of the United Nations, the international community vowed to never again allow atrocities like those seen in that conflict to ever happen again. World leaders decided to complement the UN Charter with a roadmap to guarantee the rights of individuals everywhere. The document they considered, and which would later become the Universal Declaration of Human Rights, was taken up at the first session of the General Assembly of the United Nations in 1946. You will recall that Eleanor Roosevelt, the widow of the late President of the United States, Franklin Delano Roosevelt, was the driving force behind the Universal Declaration of Human Rights. By its Resolution 217 Alpha 3 of 10 December 1948, the General Assembly meeting in Paris adopted the Universal Declaration of Human Rights, with 8 nations abstaining from the vote but none dissenting. Hernan Santa Cruz of Chile, a member of the drafting subcommittee, wrote this. He said, "I perceived very clearly that I was participating in a truly significant historic event in which a consensus had been reached as to the supreme value of the human person, a value that did not originate in the decision of a worldly power, but rather in the fact of existing, which gave rise to the inalienable right to live free from want and oppression and to fully develop one's personality. In the Great Hall, there was an atmosphere of genuine solidarity and brotherhood among men and women from all latitudes, the like of which I have not seen again in any international setting." The entire text of the Universal Declaration was composed in less than 2 years. Now, at this early stage, because of the underdevelopment of human rights law, the relationship between international humanitarian law and human rights law was not discussed. Another reason for this was the unwillingness to scrutinize the relationship. The United Nations effectively did not want the laws of war intruding into human rights because it felt that it might undermine the force of jus contra bellum, so the law prohibiting war actually taking place at all, and that it might shake confidence in the ability of the Security Council to maintain peace and security. The 48 Universal Declaration completely bypasses the question of respect for human rights in an armed conflict, while at the same time, human rights was scarcely mentioned during the drafting of the 1949 Geneva Conventions. Now, in spite of the strong view expressed by separationists, the idea that international humanitarian law and human rights law had several points of commonalities gained momentum in the early 1970s. At that time, it was argued that these two bodies of law were not only related, but also that the law of war was a derogation from the normal regime of human rights. Furthermore, and this is important, both sets of law were based in their fundamental nature upon the dignity and value of the individual human being. And it's interesting that Justice Power has already mentioned this point. Between 2009 and 2013, I found myself in Phnom Penh as the international chief prosecutor of a hybrid international court set up to prosecute the remaining leadership of the Khmer Rouge, who had, between 1975 and 1979, worked to death, starved to death, or just simply murdered between 1.7 and 2 million of their own population. Now, whilst there were some war crimes that had been committed during this period of 75 to 79 in connection with a war against Vietnam, between Cambodia and Vietnam, so breaches of international humanitarian law, we were largely addressing absolutely massive human rights violations, and we criminalized them as genocide and crimes against humanity. Before the trial, the beginning of the trial, there'd been much discussion concerning whether we had a proper legal basis for the trial. In other words, did we have legitimate jurisdiction over the crimes? And I said this in opening the case for the United Nations in 2011. In the year 1941, at the height of the Second World War, a meeting took place on a warship off the coast of Newfoundland in Canada. At that meeting was the President of the United States of America, Franklin Delano Roosevelt, and the British Prime Minister, Sir Winston Churchill. Amongst other matters, these two political giants drafted a one-page document which came to be known as the Atlantic Charter, recognizing at this time that states were largely unconstrained by law and could wage war and murder and torture their own population with complete impunity. These two men committed to paper visionary ideas of common principles for a new world order. The Charter, consisting of 3 pillars, placed commitment to human rights and the maintenance of the inherent dignity and to the equal and inalienable rights of all members of the human family. Between 1941 and 1941, the Atlantic Charter would be recast into the United Nations Charter of 1945, the United Nations Universal Declaration of Human Rights of 1948, the Genocide Convention of 1948, the Geneva Conventions of 1949, the Nuremberg Charter of 1945, and the International Military Tribunal, also of 1945, which would try the major Nazi war criminals. So all of these instruments and acts affirmed the fundamental rights of human beings, the prevention and punishment of the crime of genocide, limitations on the means and methods of warfare, and ultimately that individual criminal responsibility would lie for war crimes and crimes against humanity. So you see here, I was relying on both early international human rights treaties and international humanitarian law to make the claim that we did in fact have jurisdiction, in fact very well established jurisdiction, way before 1975 for the crimes in question. I also said in opening the case in Phnom Penh that the essence of this case rested very firmly on a self-evident principle of law and morality, that individual human beings, men, women, and children everywhere, are the touchstone of value, and that societies and states must exist for their benefit and not for the benefit of those who govern. Whilst there were war crimes in the case, as I've said, at its heart, this case was about the dignity and value of human beings and the massive human rights violations on an absolutely monstrous scale that had been committed in Cambodia over 3.5 years. The Khmer Rouge abolished the family. They prohibited religion. They banned formal education. They forced the population out of their homes into what were enslavement camps. The security services of the state relentlessly pursued perceived enemies of the state everywhere. Intellectuals, capitalists, so-called members of the middle classes, members of the former Cambodian regime, those arbitrarily cast as traitors by the regime, the Muslim Cham population of Cambodia and the Vietnamese minority in Cambodia, they were all targeted for extermination. The one most shocking thing of all is that the Khmer Rouge actually enacted legislation banning love between human beings. Reproductive capacity was to be controlled by the state. Khmer citizens discovered expressing love or affection for one another, so a parent discovered expressing love towards their own child, or an adult Khmer expressing love to another adult, were at worst executed on the spot, or at best sent off for re-education and a slow death. The case was unique in that it was huge in terms of the number of victims, 2 million dead. It was unprecedented by the fact that the victims, the people of Cambodia, had patiently waited for more than an entire generation, so over 25 years, for justice to come. There were only, frankly, 3 sets of trials in international jurisprudence that could compare in magnitude to these cases. That was the trials of the leaders of the Nazi regime between 1945 and 1946 at Nuremberg, the trials at the ICTR of those responsible for the genocide of 900,000 of the Tutsi people in Rwanda in 1994, and the trial of Slobodan Milosevic, the former president of Yugoslavia, between 2002 and 2006 at the Yugoslav Tribunal. 1 in 4 Cambodians perished under the Khmer Rouge. When judged in relative terms by the proportion of a national population who died or were murdered, The scope of this catastrophe unleashed between 1975 and 1979 had no parallel in the modern era. It is the only case in which I have ever invoked the Holocaust, because it was indeed a government-controlled campaign of mass murder and industrialized killing. Now again, while this case was tried as an international criminal trial, largely relying on the crimes of genocide and crimes against humanity, it was the condemnation of absolutely horrific human rights abuses, which had loud echoes of the Nazi death camps, the very camps which had given rise to the major post-war treaties concerning human rights. Between 1999 and 2001, I was junior prosecuting counsel on the case of the Prosecutor in General Radislav Krstić. This was a case that was tried at the International Criminal Tribunal for the former Yugoslavia. It was the first case concerning events at Srebrenica in July of 1995. It involved the mass murder of over 8,000 Bosniak men and boys in the space of a few days. Indeed, while settling my remarks for today, I realized that 29 years ago today was when the largest killing was taking place back in 1995. Almost to a man, the thousands of Bosnian Muslim prisoners captured by the Bosnian Serb forces following the takeover of Srebrenica were executed. Some were killed individually or in small groups by the soldiers who captured them, and some were killed in the places where they were temporarily detained. Most, however, were slaughtered in carefully orchestrated mass executions, commencing on the 13th of July of 1995 in the region just north of Srebrenica. Prisoners not killed on that day were subsequently bused to execution sites further north of Srebrenica in a place called Bratanac, within the scope of responsibility of the Zvornik Brigade of the Bosnian Serb Army. The large-scale executions in the north took place between the 14th and the 17th of July of 1995. Most of the mass executions followed a well-established pattern. The men were first taken to empty schools or warehouses in the region. After being detained there for some hours, they were loaded onto buses or trucks and then taken to another site for execution. Usually, the execution fields were in isolated locations. The prisoners were unarmed, and in many cases, steps had been taken to minimize resistance, such as blindfolding them, binding their wrists behind their backs with ligatures, or removing their shoes. Once at the killing fields, the men were taken off the trucks in small groups, lined up and shot. Those who survived the initial round of gunfire were individually shot with an extra round, often to the head, though sometimes only after they'd been left to suffer for a considerable period of time. Immediately afterwards, and sometimes even during the executions, earth-moving equipment arrived and the bodies were buried either in the spot where they were killed or in another nearby location. At several of the sites, a few wounded people survived by pretending to be dead and then crawled away. It was on these survivors that our case relied, along with detailed forensic evidence, intercepted military radio communications, and aerial imagery. There was even evidence of people being thrown alive into the grave pits, so literally being buried alive amongst the bodies. The trial chamber eventually concluded from the evidence that the Bosnian Serb army sought to eliminate all of the Bosnian Muslims in Srebrenica as a community. Within a period of no more than 7 days, as many as 7,000 to 8,000 men of military age were systematically massacred, while the remainder of the Bosnian Muslim population present at Srebrenica, some 25,000 people, were forcibly transferred out of Srebrenica. The trial chamber described how the Bosnian Serb army attempted to kill all the Bosnian Muslim men of military age, regardless of whether they were in the Bosnian army or not, so whether they were civilian or military status. Wounded men were spared only because of the presence of the UN protection forces, and the portion of the column, a column of men that had managed to escape from Srebrenica and get through to government-held territory, owed its survival to the fact that the Bosnian Serb army lacked the military resources to capture every single Bosnian Muslim man. The chamber concluded that the intent to kill all the Bosnian Muslim men of military age in Srebrenica constituted an intent to destroy, in part, the Bosnian Muslim group within the meaning of Article 4 of the Yugoslav Tribunal Statute, and therefore it qualified as genocide. It was a massive human rights violation. the largest mass killing on European soil since the end of the Second World War. It was also a crime against humanity and a war crime. So the case straddled both international humanitarian law and human rights law. So, concluding, I hope that you can see a concrete interplay between international humanitarian law and human rights law in these international criminal prosecutions. We are relying, indeed, we must rely on long-established principles both of international humanitarian law and human rights law in bringing these cases. Thank you very much. I'll finish there.
Well, a reminder, I think, if we didn't need one, that those who don't learn from history are condemned to repeat it. Sobering. But we've had a wide range of fascinating discussion from our panellists. Now's the chance for you as audience members to ask a question. I do have 3 on the online version, if anyone's nervous. But let's hear from you first, because you're here.
Thank you. I got 2 questions. My first question is to Ms. Justice and Power. Considering the rise of far right all around the world, except in the UK, and also increase in the geopolitical tensions all around the world, how, in your experience, how do you think the future of international human rights would be? And my second question is to Barrister Naina Patel. I would love to practice international human rights, but considering the rising bills and the cost of living crisis and the student debts, for a young person, how would it be a good choice to start practice in human rights law?
Well, thank you for those questions. The first one's pretty broad, but Master Power, perhaps if you've got a couple of thoughts about the future direction, maybe in the next decade, rather than something more unmanageable. That's pretty unmanageable as it is. So.
I suppose I can't, no one can predict the path that international human rights law is going to take, but I do perceive a greater vigilance on the part of all states that are committed to international human rights law. Because as I said earlier, certain soundings are common before crises. Attacks upon the independence of the judiciary, misinformation, disinformation, scapegoating. These are not new to our world. They're very common, and they're probably on the increase as we look across Europe and indeed further afield. So I think vigilance is the most important thing to be aware, because I think it was Madeleine Albright had said when quoting Mussolini and how democracies break down, that how do you skin or pluck a chicken? How do you skin a chicken one feather at a time? Nobody notices one little slip or 2 little slips or 3 little slips, and before you know where you are, democracy is gone. We don't have what we almost take for granted. So I suppose not taking it for granted, being hyper vigilant and aware, having discussions amongst ourselves as individuals, and not being afraid to raise the awkward question, not being afraid to challenge the racist remark, or, just having the courage, I suppose, to be human and to voice, to be a voice against the slide into anti-democratic practice. I also think it's very important at an international level for governments to keep talking. I mean, international diplomacy, so much goes on behind closed doors. We saw that with the Good Friday Agreement in Ireland. It's essential that international diplomats continue to be diplomats and to talk to each other, even in the face of apparent breakdown of human rights.
Naina, you were asked tips for getting into practice, I think.
Tips for getting into practice in a financially solvent way.
Yes, that was the challenging bit.
Yeah. I'm very happy to have a chat with you later, one-on-one, but some ideas which are maybe of wider relevance. I mean, it's obviously right that there have been very significant cuts to legal aid. However, it remains the case that if you win your legal aid case, your solicitor and yourself will be paid what are called inter partes rates, which are more comparable to normal rates for commercial work. So I suppose one answer is to take a very judicious approach to the merits, take on the cases that you advise that you will win, and that can be more viable than a series of cases where you've not been successful. A second idea is to think about the types of cases. So there are a wide range of human rights, and the sorts of clients that bring those cases vary hugely. A very striking example of an article which is often invoked by corporations or entities that are not victims, individual victims in the sense that Justice Power has described in some of her cases, is Article 1 of the First Protocol. And that can be invoked by those who have suffered deprivations of property, corporations that have been subject to regulatory powers that they consider violate their right to property, and a whole host of clients that are more solvent. A third idea is to think about a mixed practice. So I've described, I think, a range of cases where human rights throws itself up. Now, it might very well be that in some of those cases there is no option but to act on a pro bono basis, or to act at a very reduced rate. But I suppose if you take a broad approach to human rights, you are more able perhaps to do some cases that involve Article 1 of the First Protocol, where perhaps your client will be more able to pay normal rates, together with an intervention perhaps for a victim of trafficking, or an organisation representing victims of trafficking where there's no option but to do it on a pro bono basis. And then a last idea, and I don't know if Andrew has anything to add for this from the international criminal side, but there are organisations where there are opportunities for acting in an employed capacity. So there are law firms, for example, where they specialise in perhaps class actions on behalf of communities that are bringing claims against mining corporations for rights violations that they've suffered. And there are also, I think, organisations on the international stage where you can go not just as a clerkship, in a clerkship role, but on a posting, if you like, for a longer period, where probably the other panel members have more experience than I do, but they are essentially salaried positions. So they would not be practice on a day-to-day basis. You'd be taking a break from practice, but gaining, I think, valuable experience, which you could then draw on when you came back to practice.
I've got a couple of online questions, one of which is relatively straightforward to answer. Can today's cases that have been cited be circulated later by email? I'm sure we can get the details of the cases too. That's not difficult. Next question was, to what extent have technological developments allowed for easier prosecution of human rights offences, which I think is one for Andrew.
Technological advances, yeah. I mean, I think probably actually the greatest change that I've seen in that arena is the availability of online evidence. I mean, historically, in the cases that I did, we relied on witnesses. So, you know, the survivor of a massacre, of which there's only ever very few. In the Srebrenica case, we had quite primitive intercepted military communications. We had forensic evidence because we dug up the bodies and had them examined. And we did actually have some, by today's standards, quite primitive aerial imagery, which showed the digging of grave sites and the clusters of individuals being murdered. Today, I think the biggest advance, I mean, if you can call it technological, is the fact that during conflicts, there seems to be a running commentary by the parties of everything that's taking place. And, you know, without wishing to sort of give away the techniques that we use, we can gather that material in real time, you know, off the World Wide Web, off the internet, and it tells a pretty compelling story. So I think that, for me, social media, I know whether one can say that's technological, that has been the biggest change in all of this, the amount of admissions that people make online about what they're doing on the ground.
Thank you very much. We had an audience member here, this gentleman here.
Thank you so much for your fascinating panel. I'm Amir from Iran. Actually, I'm based in Shanghai. My question is that it is argued by a lot of governments in the Middle East and global thought, and also it's widely accepted by the people in this country. The human rights, it's a kind of product of the colonial era, and also let's say that kind of weaponizing, the West is weaponizing the human rights for its intervention policy. So although there is kind of course, a large part of human rights can consider it in the law of these countries, and because it's related to the dignity and the human rights and humanities, but unfortunately this kind of mindset prevented the human rights to be enhanced in this country. So pragmatically, what do you think is kind of solution for enhancement of human rights in these countries? Thank you.
So I think the question is what steps could be taken to enhance human rights protection domestically in the United Kingdom? Is that a fair summary? Naina, perhaps.
I guess the difficulty is whether one agrees with your premise. I mean, I think many people would say this country has one of the more extensive sets of protections for human rights compared with many countries around the world. I understand that it is sometimes said that human rights are a peculiarly Western concept. I think if one holds that view, then it is somewhat... I mean, if one holds that view, this country, I think, does a pretty good job of protecting this Western idea of human rights at home. Now, I don't know if I'm understanding the question correctly, but I mean, my experience of jurisdictions where there is a different approach to the common good is places like Afghanistan, which don't have a Western idea of human rights. They have a very different idea of how a community is to be protected. And the reason I think Western rights, if you want to call them that, don't have traction there is because there is a conflict between the two. There is a practice in Afghanistan called BARD, which is when there are two warring communities, a way of settling the dispute is to give a woman in marriage from one community to another. And if you look at that from a rights perspective, it's hugely problematic, obviously. If you look at it from the perspective of those practicing the practice, including sometimes the women involved, it's treated as rational for the collective, and the prioritization is for the collective. And by doing that, you create a blood tie between the two communities. You remove the incentive for them to effectively annihilate each other. So looked at through a different prism, it is rational. But if one primacy places emphasis on the individual and the dignity of the individual, it's a complete non-starter. So how would you enhance human rights protection in this country? I mean, I sort of flip the question round. I think the criticisms in this country are increasingly that we place too much emphasis on human rights. And one of the points another audience member made was that is not practical anymore, given the geopolitical shifts that we face, the cost of living crisis, etc. I don't know if someone else can do a better job of grasping the nettle, because I feel I may not have got it entirely.
Master Powell.
I don't think I could do a better job, but I think it is true to say that human rights has its origin, the whole concept of human rights, in the Judeo-Christian tradition. And of course, the three Abrahamic great religions, they all focus on respect for human dignity, on the dignity of the human person. In the religious tradition, it's created in the image of God. But that same concept of, as I said earlier, it finds its bedrock in that tradition, but it replicates itself and is reflected then in political and legal instruments and social charters. So I think, number one, to acknowledge that is the case is important. I think it's also important when we're talking about human rights discourse to remember that it's not just, human rights for me is not just about the rights of one person, because every one person is a member of a community. So it's about how do we as human beings live together in community. And I think sometimes there's a lot of talk about individual human rights, and maybe not so much talk about individual human responsibility that comes with membership of the human family, that comes with, respect for my human rights. So I think that's something that we must not lose sight of if we're going to really, if human rights dialogue and discourse is to gain traction, that it's not focused solely and exclusively on the individual, as if the individual isn't a person in community living with other people. So that's just a little contribution I think that I would have to make there. I would say, however, that institutions, I know I see Professor Brett Scharf's here and Joel Coram in the audience, they make a great contribution to ensuring that we continue this discourse and dialogue on human dignity, and that it's not something that we just think of as the past. It's an ongoing conversation that we have to have every day.
Thank you very much. I'm afraid that's all we've got time for, so I'm going to wrap up. And there has been a couple of questions about the popular reception or lack of reception to human rights jurisprudence under the ECHR, for example, in the UK and so on. But what strikes me is fundamental rights protection is not a product simply of the Convention. If we look at the English common law going back to 1215 and Magna Carta, which Andrew Cayley mentioned, there's been a long tradition of UK courts interfering with the rights of the executive when they are oppressing the rights of the individual. And there's centuries-old tradition of that. Tellingly, in the indefinite detention case in the early 2000s in the Supreme Court, it was to cases involving the Star Chamber and jurisprudence arising from the activities of the Star Chamber that the majority of the House of Lords turned when first dealing with the protections against indefinite detention that the majority ultimately upheld as a reason for requiring the government to change their policy. So the common law does have a right to play. I don't think there is an individual blueprint to fundamental rights protection that deserves to be the universal standard. Every society must take its stance differently on those issues. But I am reminded also of John Rawls's social justice book, where he recognises that adopting a veil of ignorance as to who you might be and the rights you want to have might provide a culture-free designation of the fundamental rights that should be protected. And that has found echo in the common law with rights to protection of property, freedom against torture, freedom against indefinite detention, and so on. So when one faces calls to resist the constitutionalisation of fundamental rights, be it through the Charter of Fundamental Rights of the EU, be it through the ECHR, one does need to remember what are actually people complaining about. Do they want to see the ability of a state to indefinitely detain its citizens without review from a court? Do they want to have their personal property at risk of violation without sanction? Are these things that they actually are encouraging, or is it simply the packaging that they're objecting to? And without in any way being flippant, I'm reminded that when a certain leading politician who's just been elected to Parliament for the first time complained about being cut off from his banking provider, he turned to the Data Protection Act in order to make a subject access request to understand the basis upon which he had been debanked. And I flippantly put in a LinkedIn post a suggestion that this individual was relying on EU law in circumstances where he hadn't been the most receptive individual for the dissemination of EU law principles. And what I found fascinating in some of the comments that came in, and there were a few, was a lot of people said, well, this isn't EU law, the UK had it first, and he's invoking the UK rights, and then Brussels took this law and went further with it. So it was very interesting. They didn't mind the right being exercised, but they wanted it to be branded the right way. And all I would say is I think substance is more important than the branding, and let's hope we end up in that position. I am absolutely thrilled to have had such engaging questions and such a stimulating set of presentations from our speakers tonight. Please can you join me in the customary way in thanking them very much.